Karnataka. For the petitioners,
Consider,
second set I have to file. I filed the
consider
second set.
representation.
ಇಲ್ಲ,
You will
representation ಇದೆ ಮತ್ತೆ
ಹಾ.
prayer B ಅಲ್ಲಿ we have sought for the evaluation of the structure.
ಆ representation ದಲ್ಲಿ ಏನ್ ಬರ್ದಿರಿ?
Representation ಅಲ್ಲಿ for to consider to grant me 40% of the developed land in the same survey number what is
So
been
consider
acquired.
ಮಾಡ್ತಾರೆ. If you are entitled to in law, they will
ಇಲ್ಲ,
pass out.
ಬಹಳ ಕಡಿಮೆ, like they have evaluated only 21 lakh rupee for 88 squares of building.
Like-
That's why I'll file the second set.
No need. But in the similar matters we already we cannot do that.
Representation consider ಮಾಡಕ್ ಹೇಳ್ತೀವಿ.
ಮಾಡ್ಬೇಕು. ಆ second prayer ಏನೋ ಮಾಡಿದಾರಲ್ಲ ಅದನ್ನು ಕಣ್ಣು ಮುಂದೆ ಇಟ್ಕೊಂಡು ಮಾಡ್ಬೇಕು.
Please, my lords, in my matter, my lord. Second matter, even I had sought for mandamus. My lord, they have already, my lord, we have sought for 40% of the developed land. They have, my lord, now issued the bonds to us. My lord, now only grievance of the petitioner is, my lord, I have sought for the second pair. There is a construction, my lord, measuring 88 squares, my lord. The, my lord, evaluator has valued and, my lord, awarded compensation to an extent of 21 lakhs only, my lord. There, my lord, we are agreed, my lord.
Oh, that will come.
Compensation in a.
There, my
That
lord.
is not our mandate at all. This not for compensation at all. It is for other.
To evaluate the building, that's the only
But
thing
now-
direction that we have sought for.
But consider representation, we can pass. they will-
ಆಯ್ತು, ಆಯ್ತು. So far as prayer fee is concerned, my lord.
Consider representation,
ಮಾಡ್ರಿ.
keeping in mind the prayer.
ಅದನ್ನು ಸಹಿತ ಮಾಡ್ಕೊಂಡು ಹಾಕ್ಬೇಕು.
Please.
ಮತ್ತೆ ಅವರಿಂದ ಏನಾದ್ರು ರೆಕಾರ್ಡ್ಸ್ ಇನ್ಫಾರ್ಮೇಶನ್
ಏನ್
ಬೇಕು
ಬೇಕು?
ಸಾಲಿಸಿಟ್ ಮಾಡಿ ಅದನ್ನ ಕೊಡಿ ನೀವು.
For the moment, first time ಬರ್ತಾರೆ.
This petition has the following prayers.
ಸೂರಜ್ ಪಾಟೀಲ್ ಅಂತ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ವಿ, ನಿಮಗೆ ಸರ್ವ್ ಮಾಡ್ತೀವಿ ಸರ್, ನಾನು ಕಳಿಸ್ತೀನಿ.
Next one. Learned counsel appearing for the petitioner argues that when a citizen makes a representation airing his grievance, comma, it is the bounden duty of the concerned authorities to grant redressal in accordance with law, which happens to be the mandate of Article 350 of the Constitution of India. Full stop. He also points out that apart from the grievance aired in the subject representation, there needs to be appointed an evaluator to value the building existing in the scheduled property and thereafter to allot alternate land for the value to be fixed for the construction.
But if not, my lord, if same property, my lord, is given that 40%, if this construction is covered in
The
40%.
council now adds that
Please, lords. I'm sorry.
the BDA has to explore the possibility of permitting the petitioners to retain the building itself
Please.
in accordance with the extant policy. First, next paragraph. Learned counsel appearing, the state is represented by the AGA and the BDA is represented by its senior panel counsel. First up, both they opposed the petition for some time, and having done that, now in all fairness, they assured the court that the subject representation of the petitioner would be duly considered in a time-bound way and in accordance with law. After giving an opportunity of hearing to the petitioners, provided that petitioners also cooperate in the process. First up, this is really appreciable. Next paragraph. In the above circumstances, this petition is disposed of. First up, it is open to the respondent BDA to solicit any information or documents from the side of petitioners as are required for due consideration of petitioner's grievance aired in the representation and also the one referred to in the above observations. First up, time for compliance is 8 weeks. 8 weeks. First, all contentions of the parties are kept open.
Case of-
Parts made easy.
Case of Mr. Suraj Patil, whose name is shown as for BDA, my name is shown.
Registry to delete the name of Suraj Patil as appearing for respondents 2 and 3 and print the name of Shiva Prasad Shantan Gowder as appearing for respondents 2 and 3.
Please.
Order law other person.
Much obliged.
Petitioners in this matter. This is the matter where the prayer was wrong. I filed an amendment application.
ಇದೀರಾ ಈಗ?
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Similar matters are coming up on sixth. Small
Any
petition.
objection? Amendment can objection idea.
No, my lord.
The petitioner has filed an application seeking the amendment of the petition in IA 2 of 2024 for the reasons indicated in the affidavit accompanying the application and being satisfied with the same. We deem it appropriate to allow the application seeking amendment. The petitioner shall file an amended petition in the next,
Sixth is the next statement.
Sixth.
Similar matters are.
I have it ready. I'll file it today only.
file it during the course of the day by serving an advance copy upon the counsel appearing for the respondent BDA. List the matter on sixth.
Obligation.
Allowed. Yeah, for the reasons indicated, madam. ನೀವು ಟೆನ್ಷನ್ ತಗೋಬಿಡಿ ಅವ್ರು ಮಾಡ್ತಾರೆ.
Look, this, the office objection is non-filing of the second set. It's ready, my lords. I'll file it in the.
Representation,
Yes.
consider representation.
Not that, my lords, they have started to form a road. Though, my lords, my site has been regularized by the very same committee.
Huh.
They are come before my property and they have earmarked that they are going to construct a road in, which includes the building portion also. So, my lords,
Whether regularized by the committee.
yes, yes.
If it's a building regularized by committee, my lord.
The petitioners reply.
Consider
Consider the
petitioner's reply.
representation.
That is because, my lord, they have not given me any notice.
ಆಯ್ತ್ರಿ, ಅದ್ ನೋಡಿ
Consider.
consider ಮಾಡ್ರಿ, ಅದ್ನ
ಮಾಡಿ.
opportunity of hearing ಕೊಟ್ಟು
In the meanwhile, my lord, it will be a direction that will not interfere with the regularized portion of the.
Oh, that is there. File. The petitioner is before this court, petitioner calling, seeking a direction by issuance of a writ in the nature of mandamus directing the respondent to consider the petitioner's reply and afford an opportunity of hearing before proceeding further in the matter for widening of the road, which the learned counsel for the petitioner submits is happening right in front of his property. The learned counsel appearing for the petitioner submits that the petitioner was not heard. Yavaga.
Lord, there is no opportunity given at all. They
The
have not taken the
petitioner is
40%
not heard before the earmarking of the road, before the road was marked for widening, which abuts his property. The learned counsel would submit that he has submitted a reply against the said action on 31/5/2024, which is yet to be considered at the hands of the BDA. The learned counsel appearing for the BDA would submit that the committee has regularized
Regularized an extent of building of plinth area 511.5 square feet.
the committee has, before whom the petitioner was, has regularized the area of
11.5 square feet.
511.5 square feet. And the petitioner is now seeking regularization. ಬೇರೆ ಏನ್ ಕೇಳ್ತಿದ್ದಾರೆ?
He's seeking, my lord, his grievance is that the road is passing through his land. That is not being heard.
The
Probably
grievance,
not-
the grievance of the petitioner now is that the road that is being formed would pass through his land. Be that, which, ಅಲ್ಲ regularized ಅಲ್ಲ.
Which is regularized.
ಅಲ್ಲಿ ರೋಡ್ ಬರ್ತಾ ಇದೆಯಾ?
ಹೌದು.
ಅಲ್ಲಿ
ಅವ್ರು
ಹೋಗ್ಬಾರ್ದು ಅಂತ
ಹೇಳ್ತಾ
ಹೇಳ್ತಾ
ಇದ್ದಾರೆ.
ಇದ್ದಾರೆ.
Which
This
in
is
the
their
court-
grievance.
The grievance of the petitioner in his reply appears to be that the road is passing through the area that has been regularized by the committee. If that be so, regularized by the committee, and he is not given an opportunity of hearing prior to the marking of the road for the purpose of widening. Therefore, it is, we deem it appropriate to direct the BDA to consider the reply of the petitioner dated 31/5/2024, afford him an opportunity of hearing, solicit any document that is needed for the purpose of consideration of the reply, and pass necessary orders in accordance with law. Till such time, accordance with law, it is made clear that the area that is regularized, the BDA shall not, ಅದಕ್ಕೆ ನೀವೇನು ಮುಟ್ಟಲ್ವಲ್ಲ?
No, my lord.
Let there be an order, my lord, because
It is made clear that the BDA shall not interfere with the portion that is already regularized by the committee.
Until the replies.
ಯಾಕೆ ಆಮೇಲೆ
After consideration.
ಕಮಿಟಿ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ
My lord, if the road is passing through, if there cannot be any deviation, that
All
those
right,
matters,
let's-
my lord, if they are entitled for enhanced compensation, that
That
those
is-
matters are coming up
yes.
next week.
so
Probably their
consider
land
the
falls in
reply
that
and
category.
pass necessary orders in accordance with law ಆಯ್ತಲ್ಲ. Till such time, the BDA shall not precipitate the matter qua the construction that is already regularized. Ordered according.
Those road matters are decided, probably their matter also. will
ಅದಕ್ಕೆ
fall.
ಅದರ ಆ ಕಾರಣಕ್ಕೆ ನಿಮ್ಗೆ ಲಿಬರ್ಟಿ
Yes,
ಕೊಟ್ಟಿವಿ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ. Because what law, what we are saying, going to say, we don't know.
8 weeks. salary ಹೇಳ್ತಾರಲ್ಲ.
ನಮ್ದೇ ಕೊಟ್ಬಿಡಿ. Yes, yes.
First time ಬರ್ತಾ ಇರೋದ.
Square meters, 511, it's not square feet. That regularized area.
ಹಾ ಮೀಟರ್ಸ್ ಇರ್ಬೇಕದು.
Meters.
ಹಾ.
With that for I was wondering.
511 square feet.
Meters.
ಆಯ್ತು.
Public.
In serial number, I'm sorry, in serial number 4 also,
10 into 50. ಹೋಗೇ ಬಿಟ್ರು ಅವ್ರು.
in serial number 4, my name.
4 ಅಲ್ಲಿ ಅದು ಅಷ್ಟೇ. P Vachan be deleted and Shivaprasad Shantan Gowda printed. Order ಹಾಗೆ ಮಾಡಿ. ಇದು ಫಸ್ಟ್ ಟೈಮ್ ರವಿಶಂಕರ್.
This is coming up for the first time.
Consider.
Construction
But
idea.
6 applications were filed in respect of the constructions which were existing prior
Committee
to
ಬಂದ.
3/8/2018.
ಹಾ.
3 are regularized. 3, we don't know what they have done. But yesterday, what they have done is they have demolished a portion of the compound wall which is enclosing the constructed area. I have produced the Google Maps from 2012 till date to show that these constructions are existing at least from the year 2012. Page number 10, your lordships may kindly see for a minute, my lords.
So 3/8/2018 ಇದೆ.
Yes.
Their grievances for considered representation by annexure V.
Let them not
Consider
demolish the
representation.
existing constructions till then, that's it.
Correct. But
ಅಲ್ಲ.
consider ಆಗೋವರೆಗೆ
Same protection will continue. man.
Yes.
Same protection is.
ಅಲ್ಲ mandamus to grant representation 18/4/23, 18/4/23.
Lords, there are 3 applications pending. These are the 3 applications which covers 3 factory sheds. Lords, these
What has happened? There are similar applications which were filed before committee. Pending, my lord, Supreme Court's approval are before your lordships. If an order is passed on that, probably those applications will be covered with. There are around 100 odd applications, my lord. pending
Yes.
decision.
Applications,
Yes, ma'am. That is in the first matter, report in compliance to direction of 7/3/24 in first matter, 252,
huh?
serial number 4.
Huh.
Serial number 4, reports of
20.
yes, 7/3/24. There are several such applications pending.
You, okay, Shivaprasad ಅವರೇ, you file whatever objection you want to file. We will protect him now
Please, ma'am.
and post it on 13th. Avat will dispose it.
No, my lord, we can't file objections because they are saying that they don't know the status of their application.
Therefore, we want.
The applications
say-
are with us now
Yes, my lord, the decision made on those applications are before your lordships.
in those reports.
Yes, my lord. I'm placing the report of the,
Then till the next date, don't precipitate the
but
matter.
will their interest will be protected.
Yes.
But in this
No,
report. of
we will
the-
dispose it next week after looking into that.
Yes. But if there is a direction granted to release all those reports, that would solve the entire dispute.
No, that's why we'll do it.
Sir, one just note that.
Heard the learned senior
This thing,
counsel.
right? Respect to the second,
ಗೊತ್ತಾಯ್ತು, ಇದಿದೆ.
yes,
I have it.
second page and all those.
Heard the learned senior counsel, D.R. Ravishankar appearing for the petitioner. The learned senior counsel taking this court through the documents appended to the petition would demonstrate that 6 applications that were placed before the committee were out of the 6 applications placed before the committee, 3 applications were properties in 3 applications were regularized and other 3 were not. Or he is not aware of what has happened to those applications. The learned counsel Shivaprasad Shantan Gowda submits that the status of the applications would be available in the report which is before the court now. The learned senior counsel D.R. Ravishankar submits that the BDA has now precipitated the matter by demolishing the compound that abutted the property in one of those properties which formed the part of the application. Therefore, we deem it appropriate to direct maintenance of status quo by the parties, by the BDA, where the construction till the next date of hearing. We'll post next weekend. Till the next date of hearing.
Lordships.
6th ಹಾಕಿ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಅಷ್ಟೇ. Then we'll post it on 13th.
Very well, my lords.
ಆಯ್ತು. Then status quo ಕೊಟ್ಟು.
Very well. That's, yesterday they did it, my lords. That's the reason why we had to move it yesterday and this.
Construction ಮಾಡ್ತಾ ಇದೀರಿ.
We are not carrying on any construction, my lords.
ಅದಕ್ಕೆ-
Photograph shows.
No. ಇದು ಹೊಡೆದಿರೋದು ಅವರು.
ಕಾಂಪೌಂಡ್ ಹೊಡ್ತೀರ.
ಅದು ಹೊಡೆದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಅವ್ರು ಹಾಕ್ತಾ ಇರೋದು, ನಾವು ಹಾಕ್ತಿರೋದಲ್ಲ. Please, my lords.
Similar to serial number 3, my lords, amendment application I filed.
Same order as in serial number 3, man.
This is a 2018 vacant land. It can be
All
resolved.
right, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
No, it can be resolved.
ಕವರ್ಡ್ ಅದು.
Yes, 2018 vacant. Serial number 3, my lord, is only the amendment application. There was a small building regularized. They're seeking regularization of the entire
This
structure.
is 2018 vacant land.
Indeed, my lords.
Vacant land 2018 matters are reserved by your lord.
Anyway, 13th will ಅಷ್ಟರಲ್ಲಿ ಅದು ಮಾಡ್ತಾರೆ.
My lords, if I may one more matter may make mention, my lords. It's also reserved for orders, vacant line 2018. To change my prayer in that also, my lords.
Change your prayer.
Because same incidents occurred.
Reserved.
Reserved, 25th July it was reserved. my lords.
Once it is reserved for judgment.
Very
You
well.
have seen the Justice Ravindran's judgment. Yes.
This matter is on 13th.
13th. Shankar Reddy.
Lord, washing annexures, my lord, are sought to be dispensed with. Lord, serial number 7, 8 and 9, my lord, are coming up before this court for the first
First
time.
time,
First time. And all these cases, my lord, conversion, my lord, is of the year 2005.
Conversion ಬಿಡಿ, construction
Vacant
ಇದೆಯಾ?
site
My lord,
holders.
it's all,
Vacant site.
They are very clear in their.
Conversion
also, it's a
ಯಾವಾಗ
vacant
ಮಾಡ್ತಾರೆ?
site.
purchase is also in the year 2005, my lord. All,
Maybe, sir.
my lord, adjacent properties, my lord, have already been regularized by the committee. Regularized by the committee, my lord.
Vacant site.
Vacant site.
Regularized by the adjacent properties in the very same layout. It is an approved layout, my lord.
Because of construction.
It has been constructed. my
No,
lord,
no, no. Adjacent sites are regularized because of construction.
But my lord, the entire property is
Vacant
developed.
ಇದ್ರೆ ಬರಲ್ಲ.
Entire area is developed. My lord, it is in the extreme end of the layout, my lord. Beyond that, there is no acquisition. This is the last portion of the land, my lord, which has been acquired. And beyond the acquired portion also, my lord, my lord, there are any number of constructions
They
that
had
have
to
come
go
up.
before the Bopaya committee, but now that also, my lord,
Objection.
they had to approach the,
Bopaya committee ಏನಾಯ್ತು?
because they are vacant land, vacant site holders. Revenue sites, they had to approach there, make their grievance heard there, and thereafter, my lord, on outcome of that, they had to approach the BD. My lord, the time was extended for that committee also. That also has lapsed. So,
It's not yet complete there.
yes. But they are vacant site holders.
And even the Google Maps and photographs, my lord, of all the, my lord, it is just one site in between, my lord. The others, adjacent properties are all fully constructed.
One site ಅಲ್ಲಿ ಇವರೇ 3 site ಇದ್ದಾರೆ. Like that, my lord, there are multiple site holders.
ಆಯ್ತು, we'll finish it, we'll close it on 6th.
At least one statement ಹಾಕ್ಬೇಕು.
ಏನಾರ ಒಂದು ಹಾಕಿ.
ಹಾ.
6th or 13th ಯಾವತ್ ಬೇಕಾವ್?
It's coming up for the first time.
First
Let them serve a
Council,
copy of-
Learned AG is directed to accept notice for the first respondent, 2 and 3, Shiva Prasad Shantan Gowda, petitioner to serve a requisite set of papers upon the council appearing for the BDA. Good.
My lord, in certain cases, my lord, there are constructions, photographs have been produced. In respect of certain other portions, my lord, they are vacant sites. Wherever there is construction, my lord, let them not
My lord,
demolish.
direction was to approach the committee, but now the
Ah.
committee's tenure is also over.
That we'll have to
Yes,
consider it.
probably we have to consider it.
Yes, let's see. Next week we'll do that, because committee, if they are seeking extension or whatever, we'll see.
They are seeking extension,
They ಕೊಟ್ಟಿದಾರ ಏನಾರ?
oral communication.
Let's see.
Please.
So, then we'll post it on 13th.
Any constructions, my lord, if they are found, my lord, let them not.
Construction ಇದ್ರೆ.
ಇಲ್ಲ,
ಇದ್ರೆ-
ಅವರೇ vacant ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಯಾವ್ದಾರ ಫೋಟೋಗ್ರಾಫ್ ನಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್.
My lord, their photographs. not-
ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ, ಅವ್ರ ಏನಾರು ಏನು ಮಾಡಲ್ಲ, ಮಾಡಿದ್ರೆ ಮೂವ್ ಮಾಡಿ.
Please.
Yes.
7, 8 and 9 not adopt.
Same, 7, 8 and 9, same order.
All along with each other ಮಾಡ್ಬೋದು ನಾವು.
Tag 7, 8, 9. Tag them.
10 and 11 I applied for the petitioner.
Hmm.
The writ of mandam is coming for the first time, my lord. Writ of,
Mandamus for what?
for the respondents to issue a regularization certificate.
Regularize ಆಗಿದೆಯಾ?
Agila. The only thing is
Consider,
First time.
consider
representation.
ಏನು ಏರಿಯಾ ಎಷ್ಟಿದೆ?
30-40 site, my lord, 1200 square feet.
the petitioner, ಎರಡರಲ್ಲೂ same order. The petitioner is before this court seeking the following prayer. The regularization certificate issue ಮಾಡ್ಬೇಕಾ? Regularize ಆಗಿದೆಯಾ?
I don't know. It's coming up for the first time. We don't
ನೋಡಿ.
know.
Lawful constructions
Hold on.
have been come up on the notified lands, my lord.
Yo, Prasad.
The only thing is we have approached the wrong committee.
Wrong committee.
These petitioners being illiterate and
ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾವ್ ಹೆಂಗೆ ಮುಂದೆ ಇದನ್ನ ಹೆಂಗ್ ಕೊಡೋದು? ಇಶ್ಯೂ ರೆಸ್ಪಾಂಡ್ ಅಥಾರಿಟಿ ರೆಗ್ಯುಲರೈಸ್ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಟ್ರೆ ರೆಗ್ಯುಲರೈಸನ್ಗೆ
ಹೇಳಿದ್ದಾರೆ ಸೊಲ್ಯೂಷನ್ ಹಾಕೊಡು.
They have not approached the committee.
ದಟ್ಸ್
They have not approached the
ಅಟ್ ಲೀಸ್ಟ್
committee.
ಈಗ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಡ್ಬೋದು.
Regularization ಗೆ ಕೊಡ್ಬೋದಾ?
ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ತಗೊಂಡು ಏನಾದ್ರು ಒಂದು ಡಿಸಿಷನ್ ತೊಗೊಳ್ರಿ ಅದ್ರ ಮೇಲೆ.
If it's a direction through court, not to.
That is.
That's all.
Because they have to show that the building has been constructed prior to 18 or 22.
ಅದಕ್ಕೆ ಆ ಫ್ಯಾಕ್ಚುಯಲ್ಸ್ ಎಲ್ಲ ನೀವೇ ಅಸರ್ಟ್
Yes.
ನಾವ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಡ್ಲಿ,
Please.
ಕೊಟ್ಕೊಂಡ ಮೇಲೆ ಮಾಡ್ಲಿ. ಎಲ್ಲ ವೆರಿ ಇಲ್ ಡ್ರಾಫ್ಟೆಡ್ ಪಿಟಿಷನ್ ಎನಿವೇ.
The petitioner ಎರಡರಲ್ಲೂ is before this court seeking the following prayer. ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ, ಏನದು? It is the claim of the petitioner that the buildings are to be regularized and a regularization certificate is to be issued. The petitioner avers in the petition that he had approached the wrong committee inadvertently. The petitioners appear to have approached the Bopaya committee, which was constituted for the purpose of assessment of revenue sites. Revenue site grievance, which was constituted for the purpose of redressal of grievance of the revenue site holders. The petitioner is not seeking the said relief. Therefore, he had to approach the Justice A.V. Chandrasekhar committee, which is not, whose tenure is now over. The petitioner would submit that the petitioner seeks leave to submit a representation to the respondent BDA, venting out his grievance with regard to his claim for issuance of a regularization certificate after considering regularization of the buildings in accordance with law. In accordance with law, the learned counsel would take this court through the documents and photographs appended to the petition, seeking to demonstrate that the buildings have come up prior to 3/8/2018, the cutoff date fixed by the apex court for consideration of the grievances of the petitioner's construction of the buildings. Next para. The learned counsel Shivaprasad Shantangowda submits that the factual assessment will have to be done with regard to the claim of the petitioner, the documents that he has placed before the court, or he would become necessary to place it before the BDA. In that light, we deem it appropriate to direct the petitioner to submit a detailed representation of his grievances or claims to the BDA with all supporting documents. The BDA shall thereafter consider within 4 weeks from today anta ಮಾಡಿ our representation kodakke. The petitioner shall submit a representation within 4 weeks from today. The BDA shall consider the same thereafter within 8 weeks thereafter and pass necessary orders with regard to the claim and grievance of the petitioner as would be submitted in the representation. Any information that is necessary from the petitioner shall be solicited by the BDA, and the decision taken shall be communicated to the petitioner to the petitioner. Ordered accordingly.
liberty, my lord, if need arises. If need arises, my lord, liberty maybe.
What liberty? Liberty is always
Please,
there.
please.
All contentions remain open. Make it clear that we have not considered the merit of the claim of the petitioner or the defense of the BDA. All contentions remain open. As Marthi, that will do. We'll pass an order and.
Verify applications of the. One more. Orders on the application, calling for applications. On behalf of.
ನಿನ್ ಪೈಲಿ ನನ್ನ ಪೈಲಿ ಎಲ್ಲ ಮಿಕ್ಸ್ ಆಗೋದು ಬೇಡ ಆಮೇಲೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಹಂಗೆ ಆಗಿ ಏನೋ ಕನ್ಫ್ಯೂಷನ್.
ಆಯ್ತು ನಾವೆಲ್ಲಾನು 37140 ಅಂತ ಹೇಳ್ಕೊಂಡು ಇಲ್ಲ ಇದೆ 884 ಇದೆ ಇಲ್ಲೇ ಇದೆ ಎಲ್ಲ ಟೈಪ್ ಮಾಡಿದೆಲ್ಲ ಹೊಡೆದಾಗ ಏನ್ರಿ ಅದನ್ನ ನಾನೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ಕೊಂಡಿದ್ದೆ ನೀವು anybody is there in the office? Checks. This page is change page. I put it correctly. Session no, it is G80. ಹೌದು ಇಲ್ಲಿ ಫಸ್ಟ್ ಮಾಡ್ರಿ ಏನು ಅಲ್ಲಿ ಅವರ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಜಡ್ಜ್ ಬಂದ್ರೆ ಸರಿ ಜಡ್ಜ್ ಬಂದ್ರೆ ಮತ್ತೆ ಅದು ಶುರು ಮಾಡಿದ್ರೆ ಮತ್ತೆ ನಾನು ಹೇಳ್ತೀನಿ ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ ನಾನು ಇನ್ನೊಂದು ಕೊಟ್ಟು ಹೋಗ್ತೀನಿ ಹೊಡೆದು ಬರೆದು ಹೊಡೆದು ಎಲ್ಲ ಇರ್ಲಿ ನಾನು ಅದನ್ನ ಇದು ಮಾಡ್ತೀನಿ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಕಳಿಸ್ತೀನಿ ಎಸ್ ಆಫೀಸ್ಗೆ ಯಾರಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ ಶನಿವಾರ ಅಲ್ಲ to 25
Yes, Professor.
Hearing the arguments on the urgency clause, man. We have made submissions, they have made their submissions.
Yes, you have to say it, na?
5 minutes ಏನೋ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಅವ್ರು.
Correct. One is a general accusation.
The next comes with the urgency clause.
The other part.
Other part of the 271 acres have been acquired. Out of the total extent of land of 369 acres that they own.
Yes, Mr. Holla also has come now. No, nice. He started.
My request was required to consider the parcel of land that is 100 acres, where urgency clause is invoked. In the light of the facts of the first application.
This also can be disputed.
Is connected because the state felt that 171 acres is not sufficient. And therefore, another 100 acres.
It went far.
Required invoking the urgency clause. Both has to be seen together. The Lordship considers the urgency clause independent of the first petition. May not give the true picture. Because it's like putting the cart before the horse. So.
With the greatest respect to my learned friend, that is not the contention anywhere taken, my lord, in their objection statement. Nor, my lord, does the government records, my lord, indicate this. In fact, it was agreed earlier that, my lord, this will be taken up because their question of delay within 1 year, my lord, they had to, my lord, 11A, my lord, applies. They did not pass the final notification. Therefore, my lord, it lapses. This, my lord, is a more arduous question because of, my lord, the so-called conflict between Indore and, my lord, Delhi earthquake. Therefore, my lord, my submission to your lordships is that is to be taken independently. And nowhere, my lord, I can understand if they had taken up that plea anywhere in their objection statement or, my lord, the records, nothing is there.
ನಿಮ್ದಿಗೆ ಎರಡು ಪಿಟಿಷನ್ ಮೇಲಿನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿತಾ?
ಅಲ್ಲ, ಎರಡನೇದು ನಾವು ಮಾಡಲೇ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ 3, my lord, the other one delay, that, my lord, your lordships, my lord, earlier thought, my lord, that will be taken up separately because the issue is not, with regard to the urgency clause there.
ಅದು ಆಯ್ತು. ಇವಾಗ ಅದನ್ನು ಮುಗಿಸ್ಬಿಡ್ರಿ ನೀವು. ಅಲ್ಲ, ನಿಮ್ ಬೇಕಾದ್ರೆ ಇನ್ನೊಂದು ಟೈಮ್ ಕೊಡೋಣ. ನೀವು ನೋಡ್ಕೊಂಬರಂಗಿದ್ರೆ ಇನ್ನೊಂದನ್ನ ಇವತ್ತಂಕೂ ಇದು ಇನ್ನೊಂದ್ರ ಮೇಲೆ ರಿಪ್ಲೈ ಮಾಡ್ಲಿ ಅವರು. ಅದಾದ್ಮೇಲೆ ನೀವೇನ್ರ ಆಡ್ ಮಾಡಂಗಿದ್ರೆ ಆ ಇನ್ನೊಂದು ಪಿಟಿಷನ್ದಲ್ಲಿ
ಆಯ್ತು. ರಿಪ್ಲೈ ಟು ರಿಪ್ಲೈ ಆಗಿದೆ ಈಗ.
ಇದಕ್ಕೆ ನಿಮ್ಮ
ಇರ್ಲಿ, ಡಸಂಟ್ ಮ್ಯಾಟರ್.
ನಿಮ್ಮ ಇದಕ್ಕೆ
ಡಸಂಟ್ ಮ್ಯಾಟರ್. My lord, before they start, I would also, my lord, give your lordships, my lord, 2 judgment for my lord's consideration. Please take, my lord, the judgment of the Supreme Court in 2022-21. With regard to, my lord, this urgency clause itself.
ಇಲ್ಲ ಸರ್, ಮುಂದೆ ಓಸಿ ಸರ್ ಅದು. ಅದೇ ಓಸಿ.
ಬೇಕಾ ನಿಮಗೆ?
ನಂಗೇನ್ ಬರುತ್ತೆ ಸರ್.
ಅಲ್ಲಿ ಅವ್ರದ್ದು ಇಟ್ಕೊಂಡಿದ್ದೀನಿ. ತಗೊಳ್ಳಿ. My lord, can I persuade you all to turn to page 30, para 37?
37.
Yes, my lord. This was also, my lord, under section 17. We may call out the principles at plea. What is required for the authorities to form a subjective,
We may call out.
We may call out the principles at plea. What is required of the authorities to form subjective opinion? This does not mean
The opinion can be whimsical or capricious. There must be material before the authority. Material must be relevant. Authority must apply his mind to the material. This is apart from the requirement that the action must not be malified. Undoubtedly, the purpose must be a public purpose. But merely because the purpose of the acquisition is to be found to be a public purpose, duty of the authority does not end. He must be satisfied that there is real, my lord, not agency, urgency, such that, my lord, it has to be, my lord, urgency, urgency, such that invaluable right vouchsafed to a person to ventilate his grievances against the acquisition is not unjustifiably extinguished.
Yes.
Section 538, my lord. Section 5A of the Act guarantees a right to a person interested in the property, which was the only statutory safeguard to stave off a compulsory acquisition of his property. The power under section, my lord, 5A, my lords have, my lord, if your lords recollects, Supreme Court even has held 5A is akin to, my lord, constitutional right, because it is a right to be heard, without which, my lord, that's why, my lord, permit me read 38. Section 5 of the Act guarantees a right to the person interested in the property, which was the only statutory safeguard to stave off a compulsory acquisition of the property. Power under section 17(4) is discretionary. Being a discretion, it must be exercised with due care. It is true that if there is relevant material, however meager, it may be, and authority has, without being guided by extraneous considerations, applied his mind, taken a decision, then the court would adopt a hands-off approach. In the ultimate analysis, as with any other decision, a balancing of conflicting interests is inevitable. Authorities must remain alive and alert to the precious right created in favor of the citizens, which is not meant to be a mere empty ritual. It is true again that the decision of this court appeared to convey conflicting signals. However, there is a certain element of consensus on the fundamental principles. The dichotomy essentially has to be resolved by carefully attending the facts of each case. Decision of a bench of a challenge of 3 judges in Gavate enunciated the principles relating to the manner in which a challenge to the notification of section 17(4) must be approached in the matter of discharging the burden of proof. When a challenge is made to the invocation of power under section 17(4), the writ applicant cannot succeed on bare and bald assertions. Facts which are specifically within the knowledge of the state must be laid before the court on the basis of the principles and section 106 of the Evidence Act. Existence of exceptional circumstances justifying invoking of section 17(4) must be established in the wake of a challenge. The true concept unraveled by this court in Gavate is the total evidence theory. In other words, on an appreciation of the evidence made available by all the parties, it is open to the court to conclude that no occasion arose for resorting to power under section 17(4), which indeed must be read as an exception to the general rule that the acquisition of property is made after affording an opportunity to the person adversely affected to demonstrate that the acquisition was unjustified.
Yes.
Therefore, my lord, my submission to your lordship is there must be some reason, and reason must be, my lord, by the government, not, my lord, the APMC saying, no, there is some urgency, is not. Government must apply its mind. In fact, latest judgment, my lord, I've just asked for a copy, my lord, they are getting it. 7 rules, my lord, principles have been laid down. If my lords recollects, my lord, I had also indicated on a previous occasion in another matter. The Honorable Supreme Court, my lord, in 2024, rendered by his Lordship Justice Narasimha, my lord, have laid down, my lord, 7 guidelines with regard to, my lord, the acquisition. Those guidelines are right to
Justice
Arvind Kumar. Yes, my lord. Right to, my lord, to, there are, my lord, 7 of them. One is, my lord, the right to be, my lord, right to notice. Second, right to be heard. Third, right to reasoned decision. 4, right to acquire only for public purpose. 5, right to fair compensation. 6, right to efficient and expeditious process. 7, my lord, right to conclusion. All this
right to
conclusion, my lord, because you can't keep it, my lord, alive, my lord, for years and together. In fact, Now, my lord, in this paragraph, in this page itself, please come to my lord para 60. I'll tell your lordship why in this judgment.
A short counter affidavit.
Yes. Paragraph 60, my lord. ಅದರಲ್ಲಿ the statutory authority ಅಂತ ಬರುತ್ತೆ ನೋಡಿ.
Para 16,
60, my lord, not 16, sorry.
60. The statutory
Sorry.
authority.
Under section 5 capital A of the Act is expected to give a fair hearing. It can stand between an uncalled for proposal to acquire property. Disputed questions of fact in regard to the property to acquire the property are to be considered by the same authority. Yet, another pertinent aspect is the fact that the subject matter of the second acquisition was 2 and odd hectares. It was apparently just that the appellants who had been given a hearing had to be given a hearing. We would therefore think that in the facts of the case, having regard to the nature of the scheme, delay with which section 6 was declaration was issued, possession taken and the nature, other possession taken, I'll tell you lots, in this possession is not taken, I'll point out. And the nature of the material on the basis of which the proposal was processed, appellants are justified in contending that the notification
17.4 was unjustified.
Correct. We may notice another aspect. This is also important. We may notice another aspect. This appeal arises, thank you. This appeal arises from the order passed by the High Court in the year 2009. While issuing notice, this court in the SLP stage ordered status quo as on 6/11/2009 be maintained. Thereafter, leave was granted on 27/1/2012. Interim order was, however, directed to continue. It is only after nearly 12 years that the case is finally being disposed of. Idralli 1999, 2009, 2019, 35 years. 2009, 20 years are over. Idral Namdrali, Ali 12 years. Now, please permit me to read further, my lord. In the meantime, Land Acquisition Act was repealed. Right to fair compensation, transparency in land acquisition, rehabilitation, resettlement act has taken its place. Therefore, there is no question of matter being considered for an inquiry being held under section 5B. We have also noted there is no denial of the allegations, the writ petition about the lie of the property, namely it being in the middle of the scheme area. Appeal is allowed. Impugned judgment is set aside. Writ petition file shall stand allowed. Impugned notification process, so on, so on, so. The property shall be returned back to them. Good. The judgment of my lord justice.
There they had taken possession also.
Yes. Justice Narasimha's judgment, my lord. ಇದರಲ್ಲಿ paragraph 30 ತಾವು ಬಂದರೆ
Page
30 my lord, 30. Para 29 my lord. These sub-rights of procedure, my lord, in fact, 28 ತಾವು ಬಂದರೆ 7 rights are foundational components of a law that is in tune with Article 300A. And the absence of one of these or some of them would render the law susceptible to challenge. Judgment of this court in KT Plantation declares law envisaged under Article 300A must be in line with the overarching principle of rule of law and must be just, fair and reasonable. It is, of course, precedentially sound to describe some of these rights as procedural, a nomenclature that often lends to undermine the inherent worth of these safeguards. These 7 rough sub-rights may be procedures, but they too constitute real content of the right to property under Article 300A. A non-compliance of these will amount to violations of the right being without the authority of law. These sub-rights of procedure have been synchronously incorporated in the laws concerning compulsory acquisition and are also recognized by our constitutional courts while reviewing administrative actions for compulsory acquisition of private property.
It's like Saptapadi.
Absolutely. Following are the 7 principles. Right to notice. Prior notice informing the bearer the right that the state intends to deprive. Then right to, my lord, to be heard. That's a very, 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 my lord, crucial right. Following right to be a meaningful and effective right to know prior notice of acquisition is the right of property bearer to communicate his objections and the concerns to the authority acquiring the property. This right to be heard is, heard against the acquired proposition must be meaningful, not a sham. Section 5 of the Land Acquisition Act, Section 3(1) of the Requisition and Acquisition of Immobile Property Act, Section 15 of the Right to Fair Compensation, Transparency in Land Acquisition, Rehabilitation, Resettlement Act, Section 3C of the National Highways Act, some of the statutory embodiments of this right. Judicial opinions recognize the importance of this right are far too many to reproduce. Suffice it to say, inquiry in which the landholder would raise his objections is not a mere formality. Idharalli, Section 5 is dispensed with. I will not even will be heard. Then, my lord, right to a reasoned decision. That the authorities have heard and considered the objections is evidence only through a reasoned order. It is incumbent upon the authority
To communicate also.
correct. Absolutely, my lord. Highlighting the
ಮೊದ್ಲು ಹಂಗಿರ್ಲಿಲ್ಲಲ್ಲ.
ಹ್ಮ್, ಹ್ಮ್.
ಲಾ ಮೊದಲು
ಹಾ.
ವಿ.ಜಿ. ರಾಮಚಂದ್ರನ್ ಬರೆದದ್ದು ಅದನ್ನ
ಅದ್ ಸರಿ.
ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡುವಾಗ
Lord,
ಇಲ್ಲ
what happened?
ಬರೆದಿದ್ರು.
My lord,
Now this is the law.
I'll tell your lordships why, my lord, this happens. Please look at it, this, my lord.
We should know that my
ಹಾ.
objections are looked into.
Correct. ಒಂದು. ಎರಡನೇದಾಗಿ, my lord, what we have, my lord, this is our general experience. ನಾನು ಯಾವಾಗಲೂ ಹೇಳ್ತೀನಿ, where, my lord, land, of course, I have appeared, my lord, as an advocate general, I have appeared here also. We have to be fair. What happens is, that landowner, my lord, whose farmer, whose land is acquired, by the time he gets, my lord, his compensation,
Years would lapse.
and I have always said, it is sufficient to buy him, my lord, a 3/6 so that he can bury himself. That's a sad part. Therefore, my lord, right to fair compensation, my lord, lot of changes were made. And in respect of, my lord, this special, my lord, urgency clause, they say, my lord, an additional amount of 75% has to be paid, Section 40 ಅಲ್ಲಿ, 2013 Act ಅಲ್ಲಿ. My lord, all these are rights. Ultimately, my lord, experience, my lord, will color the law, will, my lord, lend, my lord, the sinews to the law. Ultimately, my lord, law is meant for the citizens. If the citizens' rights are trampled, then, my lord, law, my lord, evolves. In fact, right to, my lord, private property, my lord's, my lord, recent judgment. Of course, one dissenting judgment is there, but majority is, my lord, it can be, my lord, right to property and exceptions, my lord, can be private property, can be acquired. But then it has to be, my lord, justified. It has to have some meaning. Otherwise, my lord, 300 days is a variable right. Then, my lord, right to reasoned decision, 30.3. Authorities have heard and considered the objections evidence only through a reasoned order. It's incumbent on the authority to take an informed decision and communicate the same to the objector. Section 6 of the Land Acquisition.
ಇದು ಇರ್ಲಿಲ್ವಾ ಮೊದ್ಲು? Communicate to the objector ಇದ್ದಿದ್ದು ನಾನು ನೋಡಿರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿದೆ.
ಅದೇ ಹೇಳಿದ್ ನಾನು. ಇದೆಲ್ಲ, that's why I said,
New development.
naturally, in the
But
course.
that makes sense also. Well, that whatever objections we have given, at least after seeing their report, they have considered.
ನೋಡಿ,
Maybe
ಇದು ಹೇಗೆ
not
ಅಂತ-
to our satisfaction, but at least
ಹೇಗೆ
consideration.
ಅಂತಂದ್ರೆ,
ಹಾ.
ಜಡ್ಜ್ಮೆಂಟ್ ತಾವು ಜಡ್ಜರ್ ಕೊಟ್ರೆ ನಾವು ಓದಿ, ಹೌದಪ್ಪ ನಾನು ಏನೋ ಹೇಳಿದ್ದಾಗಿದೆ ಅವರಿಗೆ. ಮೆನಿ ಅ ಟೈಮ್ಸ್ ಕ್ಲೈಂಟ್ಸ್ ವಿಲ್ ಸೇ, ನೀವ್ ಹೇಳೋದೆಲ್ಲ ಹೇಳಿದಿರಿ ಸರ್, ಅವರಿಗೆ ದೇವರು ಈ ತರ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ವಿ ಅಕ್ಸೆಪ್ಟ್ ಇಟ್. ಬಟ್ ದೆನ್ ಮಲಾಟ್ ದೇರ್ ಮಸ್ಟ್ ಬಿ ಅ ಜಡ್ಜ್ಮೆಂಟ್, ದೇರ್ ಮಸ್ಟ್ ಬಿ ಅ ರೀಸನ್ ಆರ್ಡರ್.
Correct.
Otherwise, ಮಲಾಟ್ ಇಟ್ ವಿಲ್ ಬಿಕಮ್ ಎ sham. And many a times it is our experience, as I said, ಮಲಾಟ್, sitting both that side and this side, many of them absolutely, my lord, there will be no reasons. It is, my lord, simple my marji. That, my lord, can't be. Whimsical and capriciousness, my lord, should, my lord, excludes everything.
Communicate ಮಾಡಬೇಕು.
Reason.
They said communicate also.
Correct. Highlighting, my lord, 3 ಅಲ್ಲಿ,
But
330.
however, in one case that would not arise because very inquiry itself.
ಅದಕ್ಕೆ first, right to be heard is totally dispensed with, 30.2. Therefore, my lord, other thing does not arise. Then duty to, my lord, acquire for public purpose, no difficulty about it. That is, my lord, 30.4. Then, my lord, 30.5.
Fair compensation.
Yes.
Restitution.
Restitution of fair compensation. A person's right to hold or enjoy a property is an integral part of the constitutional right under Article 300A. That's why I said, my lord, the latest decision of the 9-judge bench, 300A, my lord, is given prime importance. Deprivation or extinguishment of that.
30.5. Little it runs counter to Keswananda. Though Keswananda considered right to property when it was a fundamental right.
Correct.
Even there, Supreme Court said, recompensate need not be the equivalent value of the
That's all right.
property.
That I
acquired.
agree. That I agree, my lord. Let's again look at.
This is when,
Huh.
Mr. Holla, this is when right to property was a fundamental right.
Correct. Now they have.
After it is a,
Excess of the ceiling.
Professor?
It's in excess of the ceiling limit, my lords. If it's within the ceiling limit, fair compensation is market value of the property. If acquisition is beyond the ceiling limit, like my lords, under the Land Reforms Act, 54 acres we hold. When the the lands were taken
Right.
away, it's more than 54 acres. These matas used to have hundreds and thousands of acres. So in respect of ceiling limit, more than exceeding ceiling limit, you will only given a compensation that you cannot say it should be equivalent to the market value.
But Keswananda does not say that. Keswananda says the word, because they substituted the amount to compensation, which you have seen in 31C. There they interpreted what is meant by this amount. This amount should not be illusory.
Correct.
Is one view.
Correct.
This amount is not equivalent to exact restitution.
That's all right. That, my lord.
Is another.
Correct.
In between these two, the Keswananda operated. But here, 30.5, it is structured little in variance with
My
Keswananda.
lord, can we read it again, my lord? Subject to your lordship's, my
A
lord.
person's
correcting me.
right.
That is, nodi. A person's right to hold and enjoy property is an integral part of the constitution, right? And that's the 300A. My lord, this, nobody, my lord, can
Correct.
dispute. Then, deprivation or extinguishment of that right is permissible only upon restitution, be it in the form of monetary compensation, rehabilitation, or other similar means. Compensation has always been considered as an integral part of the process of acquisition. Compensation.
So
just
that we understood. The question is, what is meant by compensation? The idea of the
No,
apex court now, this runs
fair compensation.
There's a fair compensation.
Even that,
This was under the old act and
KT
this was under the new act.
new act. KT plantation also says, my lord, holds, if your lordship recollects, my lord, KT plantation, we argued, my lord,
Yes,
so
yes, I know
extensively in
that.
that Mulgar's case.
Whole anyway.
KT plantation also says, my lord, it has to be, my lord, fair. ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Yes, that's true.
ಅಷ್ಟೇ ಅದಕ್ಕಿಂತ ನಾನು ಹೆಚ್ಚು ಇದಕ್ಕೆ ನಾನು I won't say. Even here, I would say, my lord, compensation has to be, my lord, for the process of restitution. ಅಷ್ಟೇನೆ. Restitution ಅಂದ ತಕ್ಷಣ ಪೂರ್ತಿ ಆಗ್ಬೇಕು ಅಂತ ಇಲ್ಲ ಅಂತ ಅಷ್ಟೇ. That is all I would say, my lord. Let's have it again, my lord. Let me look at it again, my lord. A person's right to hold, enjoy property is an integral part of the constitutional right under Article 300A. Deprivation or extinguishment of the right is permissible only upon restitution. Question is, restitution is full ಆಗ್ಬೇಕು, part restitution.
Russell on restitution. The famous author, English author, Russell on restitution. I know High Court Library. That he says restitution means full only. But anyway, we have to interpret it in the light of various our decisions.
ಅದನ್ನೇ ಹೇಳಿದ್ ನಾನು ಅಷ್ಟೇ. I know, my lord. Sometimes what happens is,
ಏನೋ ಒಂದು ಇದರಲ್ಲಿ
ಒಂದು ಬರೆದಿರ್ತಾರೆ. ಅದನ್ನ we will have to interpret it, my lord. ಏನು?
Even ಏನಲ್ಲಿ it should be not less than market value.
ಸರಿ, ಅದನ್ನೇ ಹೇಳಿದ್ದು ಸಾಹೇಬರು. 31A ನಲ್ಲಿ not less than the market value ಅಂತಿತ್ತು. ಅದನ್ನ, my lord, since it was deleted, they said market value ಬೇಕಾಗಿಲ್ಲ. But it has to be, my lord,
amount ಅಂತ ಬರೆದ್ರು.
Amount.
ಅಲ್ಲಿ ಪಾಲ್ಕಿಯವಲ argument was
correct.
1 rupee is also amount. In Professor Upendra Bakshi's Constitutional Quicksands of Keswananda. That's the
Correct. You know,
this one. It cannot be, what you say is, though it is not restitution as such.
As understood, my lord, in Russell.
But it should have some nexus.
Next.
Apex Court said there should be some nexus between the true value of the property, market value of the property, and the amount you are fixing. Because instead of compensation, you are saying amount. That cannot be illusory.
In fact, ಮೂಲಗಾರ ಇದರಲ್ಲಿ ತಾವು ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಬರ್ದಿದ್ದೀರಿ ನಾನು.
ಹೌದು, ಗವರ್ಮೆಂಟ್ should consider whether it can be raised ಅನ್ನೋ ಇದರಲ್ಲಿ.
ಅಷ್ಟೇ. More than that, my lord, I will say, my lord, that lays down the correct law would be my submission. ತಾವಲ್ಲಿ ಬರೆದಿದ್ದೀರಲ್ಲಿ ಲಾಸ್ಟ್ ಬಟ್ ಒನ್ ಪಾರ.
ಈಗ ಅದ್ರ ಏನೋ ಅಪೀಲ್ನಾಗ ಇರಂಗ್ ಕಾಣ್ತದೆ.
ಇಲ್ಲ, ಅಪೀಲ್ ಇದೆ, ಅಡ್ಮಿಟ್ ಆಗಿ ಸ್ಟೇ ಆಗಿದೆ, ಅದು ಬೇರೆ.
ಇಲ್ಲ, ನೀವ್ ಹೇಳಿದ್ದನ್ನ ಇದನ್ನ ತೆಗೆದು ನೋಡ್ರಿ ಅಂತ ಹೇಳ್ತೇನೆ ಆ ಜಡ್ಜ್ಗಳಿಗೆ. ಸರಿ ಇದೆ ಅಂತ ಹೇಳಿ. Anyway, so what you say is the rights have some, they should be given some meaningful,
That's all.
content ಅಂತ ನಿಮ್ದು.
And ಅದು ಒಂದು. ಎರಡನೇದು, in the light of, my lord, the experience that we have, my lord, have had over the last, my lord, 75 years. Because acquisition, my lord, has become rampant. Therefore, my lord, they came up with this 2013 Act, which, my lord, reduced it so drastically. In fact,
that's true. The legislative movement, perhaps judicial movement also, if you just survey the law relating to land acquisition and compensation, gradually they were, earlier, the 4 amendments from Shankari
my lord, what happened is, earlier it was a Fabian, my lord, socialistic theory. Over the years, my lord, it has scaled down. One. Secondly, what also happens is experience. ಲ್ಯಾಂಡ್ ತಗೊಂಡ್ಬಿಟ್ಟು 20 ವರ್ಷ ನೀವು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ತಿದ್ರೆ ಅವ್ನು ಏನ್ ಮಾಡೋದು, ಅವನು ಸುಯಿಸೈಡ್ ಮಾಡ್ಕೋಬೇಕು. Therefore, my lord, all these laws have come about, these changes have come about. Even in this case, now please look at it. 20 ವರ್ಷ ಆಯ್ತು.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಆಸ್ಪೆಕ್ಟ್ ಇದೆ, 2-3 ಆಸ್ಪೆಕ್ಟ್ ಇದೆ. With the little experience, your experience is enormous is another thing. The time gap between acquisition and the payment of compensation. By that time, the rupee is falling. The price of the consumer box, commodities in the consumer box, that is going up
Drastically.
Exponential. This is not taken
Matching
care
at all.
by whatever method, capitalization method, whatever Supreme Court says, because we have not seen the economics at all that from that angle. Number 1. Number 2, the market value which we pay is not truly reflected in the deeds. There is always
Absolutely.
gap between the market value and the notified value.
Absolutely, my lord. This is, I know it because one of my cousin purchased a property. He's been trying to sell it. He says, I don't want 1 rupee of black money. For the last 6 years,
But he will come forward.
ಏನು ಯಾರು ಬರೋದಿಲ್ಲ.
This aspect, very frugally that has been treated by some very few judgments I have seen.
Correct.
But this is very reality it is. It's a reality.
Yes.
In some judgments, the Supreme Court has said, it said like that. There is always a big gap between the notified value and the
Actual market
amount he will pay for buying that property.
ಅದು ಒಂದು. ಎರಡನೇದ್ದು 20 ವರ್ಷ ಆಗೋಷ್ಟೊತ್ತಿಗೆ
ಮುಗಿದೆ.
ಅಲ್ಲೇ ಪ್ರಾಬ್ಲಮ್.
Perhaps ಅದನ್ನ ರೈಟ್ ಟು ಕನ್ಕ್ಲೂಷನ್ ನೀವು ಹೇಳಿದ್ದು ಅದನ್ನು
ಅಲ್ಲಿ ಬರುತ್ತೆ ಅದು.
ಬೇಗನೆ ಮುಗಿಬೇಕಲ್ಲ.
ಅದಕ್ಕೆ 30.6 ನೋಡಿ. Right to efficient and expeditious process.
Correct.
The acquisition process is traumatic for more than one reason. Administrative delays in identifying the land, conducting inquiry, evaluating objections, leading to final declaration, consume time and energy. Further, passing of the award, payment of compensation, taking over possession are equally time consuming. It is necessary for the administration to be efficient in concluding the process, and within a reasonable time, the obligation must necessarily form part of Article 300A. Then, my lord, they refer to, my lord, all these other my lord, provisions where they say process, yes, my lord, with stipulated timelines. Then, my lord, right to conclusion.
Three, on multiple occasions,
Upon failure to adhere to the timeline specified in law, courts have set aside the acquisition proceedings. Number of judgments, my lord, they have referred to, my lord, number of judgments. Ali, last page alli ella hakidare.
upon conclusion of process of acquisition, payment of compensation.
Then, of course, conclusion, my lord. Payment of state takes possession of the property in the normal circumstances. Culmination when acquisition process is not in the payment of compensation, but also in taking over the actual physical possession of the land. If possession is not taken, acquisition is not complete. With the taking over of the actual possession after the normal procedure, so on and so.
Obligation to conclude and complete the process of acquisition is also part of Article 300. 16 of the Act.
Yes. Then, my lord, para 31. Their lordships hold 7 principles which we have discussed are integral to the authority of law, enabling compulsory acquisition of private property. Union and state statutes have adopted these principles, incorporated them in different forms in statutes, providing compulsory acquisition. That's why, my lord, 2013 Act is a lot, there is a lot of departure from the 1894 Act.
1894 Act was more, it was more capitalistic in nature, and it was of a colonial law. It was a colonial law. So naturally,
They
the
could, my lord, take our
colonies-
land, my lord, at any time.
Well, we
anything.
want to, we'll take that way it was.
Union and state statutes have adopted these principles, incorporate them in different forms in the statutes, provisions, provisioning compulsory acquisition of immovable property. Importance of these principles, independent of the statute provisions, have been recognized by our constitutional court. They have become a part of our administrative jurisprudence. Then, my lord, conclusion. Turning to the legal submissions of the council for the appellant corporation, we have noticed, my lord, then they, my lord, refer to all these. The 7 sutras.
Yes.
Then, of course, their, my lord, their lordships, my lord, found that, my lord, none, I mean, these principles were not adhered to, therefore, my lord, they set aside the acquisition.
Urgency clause is not treated.
All, idರಲ್ಲಿ urgency clause ಇಲ್ಲ.
Even their fairness will operate is your.
Naturally. ಅದಕ್ಕೆ urgency clause ಗೆ ನಾನು ಅದನ್ನ Justice Joseph's judgment, my lord, and Justice Ravindra Bhatt's judgment, which I pointed out to your lordships, where their lordships, my lord, specifically hold. It's a valuable right. 5A, my lord. In fact, I didn't want to, my lord, unnecessarily burden your lords. 2011, Justice Singhvi's judgment is there, of the Supreme Court, where he has held 5A is akin to, my lord, constitutional right, because it's a right to be heard.
Not simple adi alterem partem.
ಇದಿರ್ಲಿ, ಇದು ಆಮೇಲೆ ಅವ್ರಿಗೆಲ್ಲ ಏನ್ ರಿಪ್ಲೈ ಬರುತ್ತೋ ನೋಡ್ಕೊಂಡು ಕೊಡ್ಬೇಕು, ಸೇರಿಸ್ಬೇಕು. ಅದನ್ನು ಮುಗಿಸ್ಬಿಡ್ಬೋದು. ಆಯ್ತು.
Yes.
Therefore, my lord, in the instant case, there has been a total non-application of mind. In fact, they wanted, my lord, this land. They said, now we are going somewhere else. And, my lord, we do not want Sri Gandhat Kaval land. Sri Gandhat Kaval, my lord, they wanted to acquire, my lord, about 100 and odd acres. They have given up because they said we have Dasanpura market. Right. That, my lord, statement was made, my lord, in a writ petition. Judge records it way back, my lord, about 25 years back. After, my lord, I pointed to all that. They have now filed a review. Adan review innu tarsil.
ಯಾರ ಮುಂದಿದೆ ಅದು? Notice ಆಗಿದೆ. ಯಾರ ಮುಂದೆ?
So Honorable Justice Hemant Chandan, notice has been issued. There are some 300 respondents.
300A, 300.
Honorable Justice Hemant Chandan noted that it's an obvious mistake. That's why he issued
I don't know.
notice.
This is all, my lord, this obvious mistake ಅಲ್ಲ ನಾವು ಹೇಳ್ತೀವಲ್ಲ ಅಲ್ಲಿ ಅವ್ರನ್ನ ಕೇಳಿದ್ರೆ ನಾನು ಏನು ಹೇಳಲಿಲ್ಲ ಅಂತಾರೆ. ಇದು ನಿನ್ನೆ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಅಂತ ಆ ಜಡ್ಜರ್ ಹಂಗೆ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಓರಲ್ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ನಾನು ಕೇಳಿದೆ ಎಲ್ಲಿದೆ ತೋರಿಸಿ. ನಾನು ಇದ್ದೆ ಅವತ್ತು, ನೀವು ಇರ್ಲಿಲ್ಲ. ಐ ನೋ ವಾಟ್ ದ ಜಡ್ಜ್ ಹ್ಯಾಸ್ ಸೆಡ್ ಅಂತಂದ್ರೆ ಆಮೇಲೆ ಸುಮ್ಮನೆ ಅದು ನಾನು ಇನ್ನು ಇದಕ್ಕಿಂತ ಹೆಚ್ಚು ಹೇಳೋದಿಲ್ಲ ಸ್ವಾಮಿ.
CPC requires every order to be in writing. Mostly it is very, very safe one. At least now we have system where we can ascertain, but they will not become part of the record. ಏನೋ ಎಷ್ಟೋ ಹೇಳ್ತೇವೆ ನಾವು, ಏನೋ ಏನೇನೋ ಮಾತಾಡ್ತಿರ್ತೇವೆ ನಾವು, ಇಲ್ಲ ಅಂತಲ್ಲ. ಬಟ್ ಆಲ್ ದಟ್ ವಿಲ್ ನಾಟ್ ಬಿ ಪಾರ್ಟ್ ಆಫ್ ಇಟ್. ಒಂದು ಸ್ಮೂತ್ ಫ್ಲೋ, ಒಂದು ಥಾಟ್ ಪ್ರೊಸೆಸ್ ಇನ್ ದ ಮಾರ್ಕೆಟ್ ಪ್ಲೇಸ್ ಆಫ್ ಐಡಿಯಾಸ್, ಅಲ್ಲೇನೋ ಒಂದು ಆಗ್ತಿರ್ತದೆ ಅಷ್ಟೇ. ಆಲ್ ರೈಟ್.
Therefore,
ನೀವು ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಅನ್ನ ಇದನ್ನ ಡಿಸೈಡ್ ಮಾಡಿ ಸಾಕು, ಅದನ್ನ ಡಿಸೈಡ್ ಮಾಡೋದು
ಈಗ ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಅದು ಕ್ವೆಶ್ಚನ್ ಈಸ್ ಡಿಫರೆಂಟ್. ಅದರಲ್ಲಿ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಡಿಲೇ ಅಂಡ್ ಆಲ್ ದಟ್ with regard to the final notification. ಇದರಲ್ಲಿ ಮುಲಾಟ್ ವೆದರ್ 80% ಈಸ್ ದಿಸ್ ಇಸ್ ದ ಮೋರ್ ಕ್ಲಿಷ್ಟವಾದ ಪ್ರಶ್ನೆ ಇದರಲ್ಲಿದೆ. And ಮುಲಾಟ್ ದಿಸ್ ವಾಸ್ ಹರ್ಡ್ ಎಕ್ಸ್ಟೆನ್ಸಿವ್ಲಿ.
ಆಫ್ ಕೋರ್ಸ್ ಮೋರ್ ದೆನ್ ಎಕ್ಸ್ಟೆನ್ಸಿವ್.
ನಾನು ಅಲ್ಲ, ಅದು ತಮ್ಮ ಕೃಪೆ, ತಮ್ಮ ದಯೆ, ತಮ್ಮ
ಡೂಯಿಂಗ್ ಅವರ್ ಜಾಬ್ ಅಷ್ಟೇ. ಕೃಪೆ
It has been a great learning experience.
ಇಟ್ ವಾಸ್ ಆಲ್ವೇಸ್ ಲೈಕ್ ದಟ್ ನಾ.
Lordship and
The order of the remand of your while remanding the matter back, I would like to read well. In view of the above description and for reasons stated above.
ಇಲ್ಲ ನಿಮ್ಮ ಹತ್ರ ತೆಗಿ.
Common judgment, the order was
Passed.
By virtue of the order of the Supreme Court, both the appeals were remanded back. All these appeals are allowed. The review, common judgment and order passed by the division bench of the High Court, as well as common judgment and order passed by the High Court. In writ petition number 3884 and 37140, 2000 are hereby caused and set aside. Matters are remanded back to the learned single judge to decide in dispose of the aforesaid writ petition afresh and in accordance with law and on their own merits. The learned single judge to adjudicate all other issues which were framed, reproduced herein and pronounce the judgment on all points framed for consideration. The aforesaid exercise.
ಏನೇನ್ ಪಾಯಿಂಟ್ಸ್ ಅವ್ರು ಫ್ರೇಮ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದು ನಮ್ಗೆ ನಿಮ್ಮಲ್ಲಿ ಕಾಪಿ ಇದೆಯಾ? ಇನ್ನೊಂದು ಒಂದು ಕಾಪಿ ಇದೆಯಾ? ಅಲ್ಲೇನಾದ್ರು ಇಂಡಿಕೇಶನ್ ಇದೆಯಾ? ಎರಡು ಜೊತೆಗೆ ಡಿಸೈಡ್ ಮಾಡಬೇಕು ಅಂತ ಏನಾರ ಎಲ್ಲಿ ಇಂಡಿಕೇಶನ್? ಅದಕ್ಕೆ ಕೇಳಿ, ವಾಟ್ ಆರ್ ದಿ ಪಾಯಿಂಟ್ಸ್?
points at page 83.
83 ಕೊಡಿ. ಆ ಇಂಡಿಕೇಶನ್ ಇತ್ತು ಅಂದ್ರೆ
Paragraph in the judgment. In fact, one of our contentions is that only those contentions are available for us. Even in para 3.13, it's called out.
ಆಯ್ತು, ಪೇಪರ್ ಇದು ಜಾಸ್ತಿ ಮಾಡಿದ್ರೆ ಹಿಂಗೆ ಆಗುತ್ತೆ.
ಅಲ್ಲ, 8.2 ಕ್ವಶನ್ಸ್ ಈಗ ಆರ್ಗ್ಯೂ ಮಾಡಿದ ಕೇಸಿಗೆ ಅಷ್ಟೇ ಕನ್ಫೈನ್ ಇದ್ದಂಗಿದೆ, ಇನ್ನೊಂದಕ್ಕೆ ಅಪ್ಲೈ ಆಗಂಗಿಲ್ಲ. ಅದು ಅದರ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ವಿಲ್ ಸಿ ವಿಚ್ ಇಸ್ ದಿ ಅದರ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
Same points have been called out again at para 3.13.
3.13.
ಸೇಮ್ ಥಿಂಗ್ ಮೇಡಮ್.
ಅದೇ ರಿಪೀಟ್.
But it was a common order passed.
ಅಲ್ಲ, ದಟ್ಸ್ ಆಲ್ that you have read now. ಎರಡನ್ನು ಒಂದೇ ಸರಿಗೆ ಮಾಡಬೇಕು, ಕಾಮನ್ ಆರ್ಡರ್ನ ಮಾಡಬೇಕು ಅಂತ ಎಲ್ಲಿ ಇಂಡಿಕೇಶನ್ ಇದೆ ಏನು ಅಂತ. ಐಡಿಯಲಿ ಸ್ಪೀಕಿಂಗ್ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡೋದು ದಟ್ಸ್ ಆಲ್ ರೈಟ್. ಅನದರ್ ಥಿಂಗ್, ನಾವು ಇದರಲ್ಲಿ ಎಲ್ಲೂ ಈಗ ಮ್ಯಾಟರ್ಸ್ ಪೆಂಡಿಂಗ್.
From the beginning, it was a common order.
ಪ್ಲೀಸ್ ಕಮ್ ಟು ಮಿಲಾಟ್ para 12 ಬನ್ನಿ, ತೋರಿಸಿ.
ದಟ್ಸ್ ಆಲ್ that we have read na.
para 12 ಬನ್ನಿ.
12
ಹೌದು. In view of the last but one page. In view of the above discussions and for the reasons stated above, all these appeals are allowed. Sorry. Ilva.
Full. All. No issue. In view of the above discussion.
For the reasons stated above, all these appeals are allowed. Impugned common judgment and order passed by the division bench of the High Court as well as the common judgment passed by the High Court in writ petition number so and so are hereby set aside, quashed and set aside. Matters are remitted back to the learned single judge to decide and dispose of the aforementioned writ petitions afresh in accordance with law on their own merits. Andre artha enu? In the light of the questions framed, in the light of this, on their own merits.
Correct. That's similar to paragraph 13.3, section 17, is the issue.
ಅಲ್ಲ
there.
ನಾವು ಇನ್ನೊಂದು ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದ್ದೇವೆ ನಿಮ್ಗೆ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಅನ್ನು ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಏನಾದ್ರೂ ಪ್ರೊಸೀಜರಲ್ ತೊಂದರೆ ಇದೆಯಾ?
ಇಲ್ಲ, ಮಾಡ್ತೀನಿ ನಾನು, ಮಾಡ್ತೀನಿ, ಮಾಡ್ಲೇಬೇಕು ಅಂತ ಮಾಡ್ತೀನಿ ನಾನು. ಅಂದ್ರೆ ಕನ್ಫ್ಯೂಷನ್. See, what happens is, I'll tell you lordships, whole idea is, ಇವತ್ತಿನ ದಿವಸ ನನ್ನ ಪೇಪರ್ಗಳು 2 ಬಂಡಲ್ ಆಗಿದೆ, ಅದು 3ನೇ ಬಂಡಲ್ ಆಗುತ್ತೆ. ಅದು ಸುಮ್ಮನೆ ಒಂದನ್ನು ಮುಗಿಸಿದ್ರೆ ನಿಮ್ಮ ಹತ್ರನೇ ಇಟ್ಕೊಳ್ಳಿ, ನೀವೇ ಹಿಯರ್ ಮಾಡಿ. ಅಲ್ಲ ನೋ ಮೈ ಲಾರ್ಡ್, ಯು ಆರ್
ಎರಡನ್ನೂ ಹಿಯರ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋ ಇಂಡಿಕೇಶನ್ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಹಂಗ್ ಮಾಡ್ಬೋದು ಐಡಿಯಲಿ ಸ್ಪೀಕಿಂಗ್ ಅಂತ. ಅಲ್ಲ ಅದು
ಗೊತ್ತಿಲ್ಲ ನನಗೆ, ನೀವು ಮಾಡಲೇಬೇಕು ಅಂತ ಮಾಡ್ತೀನಿ ನಾನು, ಐ ಹ್ಯಾವ್ ನೋ ಪ್ರಾಬ್ಲಮ್. ಬಟ್ ಏನಾಗತ್ತೆ, ಎಲ್ಲ ಕನ್ಫ್ಯೂಷನ್ ಕನ್ಫೌಂಡೆಡ್ ಬೇಡ. ಒಂದಿನ ಇದು ಸೆಕ್ಷನ್
ಕನ್ಫ್ಯೂಷನ್ ಏನಾಗಲ್ಲ ಬಿಡಿ, ನಮ್ಗೆ ಬೇಕಾದಷ್ಟು ದಪ್ಪ ಇರ್ಲಿ ಎಂದು ಕನ್ಫ್ಯೂಷನ್ ಆಗೋದಿಲ್ಲ ನಮಗೆ. ಕಟ್ ಮಾಡಿ ಹಾಕೇ ಬಿಡ್ತೇವೆ ನಾವು.
My lord, if lordship permits me, I would like to say that both matters have to be heard together. The reason is that here there is a contention that valuable right of FIA is deprived to them.
ರಿವ್ಯೂ ಆಗೋ ತನಕ ನಾವು ಕೊಡಲ್ಲ. ಆ 300 ಜನರಿಗೆಲ್ಲ ಹಾಕೊಂಡು ಬರೋ ಅಷ್ಟೊತ್ತಿಗೆ ಈಗಿರೋ ಆಫೀಸ್ ಬೇರೆಯವ್ರು ಯಾರು ಉಳಿದ್ರು.
No, I bow down to that. I bow down to that.
ಏನಿದೆ ಆ ಪ್ರಕಾರ ನಾವು
Yes, yes.
ಗೋ
Yes,
that ಅಷ್ಟೇ.
Lord, may I submit?
ಅಟ್ ಲೀಸ್ಟ್ ನೀವು ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಅವರಿಗೆ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಹಿಯರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಅವ್ರ ಮುಂದೆನೆ ಹೋಗ್ಬೋದು. ಅಥವಾ ಇವುಗಳನ್ನು ನಿಮ್ಮ ಹತ್ತಿ ತರಿಸ್ಕೊಳ್ರಿ, ಏನಾರ ಒಂದು ಹೇಳ್ಬೇಕು. ಅಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಇಟ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ನಾವು ಹೆಂಗೆ ಮಾಡ್ಬೇಕು?
Yes, I bow down. But our request also, humble request is, both the matters could be heard and.
ಆಗ್ಲಿ, ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀನಿ, ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ. ಇದೆಂಕೋ ಆಯ್ತಲ್ಲ ಈಗ.
So because Mr. Raghavan has been addressing on both the points, so it will be.
ಬಿಟ್ರಿ ರಘುವನ್ ಅವ್ರು ಮಾಡ್ಲಿ ಅಲ್ಲ, ಅವ್ರೇನಂದ್ರು ಅಂದ್ರೆ ಇದಕ್ಕೂ ಅದಕ್ಕೆ ಏನ್ ಸಂಬಂಧನೇ ಇಲ್ಲ. ಒಂದು ಅರ್ಜೆನ್ಸಿ ಕ್ಲಾಸ್ ಆಗಿದೆ, ಒಂದು ನಾರ್ಮಲ್ ಪ್ರೊಸೆಸ್.
I would like to differ from that, my lord.
I don't want to stand on any, my lord, that technicality.
My lord, I would like to differ. The reason is, in the other writ petition where 171 acres has been acquired, there they have filed their objections. Now it is in respect of the very same parcel of land where the urgency clause has been invoked, my lord. Your lordship will have the benefit of the objections that they have filed. What is the stand that they have taken?
ಬಿಡಿ, ಬೇಕಿಲ್ಲ. ಅವ್ರು ಒಪ್ಪಿಟ್ಟಿದ್ದಕ್ಕೆ ಆ ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ. ಒಂದೇ ಒಂದು ಅಪ್ರೆನ್ಷನ್ ನಮ್ಗೆ ಕನ್ಫ್ಯೂಷನ್ ಆಗಬಾರ್ದು ಅನ್ಕೊಂಡು they wanted to be cautious, rightly, in the interest of his client. He is more than justified in saying, but I assure you,
No,
I will never get
my lord,
confused.
I know that. I
But
absolutely
we
know it.
understand. We understand the
Papa,
anxiety because
I have known,
ಈ ಗದ್ದಲದಲ್ಲಿ ಕ್ಲೈಂಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಕಳೆದು ಹೋಗಬಾರ್ದು ಅನ್ನೋದು ಒಂದು anxiety ಇದೆ.
my lord, I have known your lordships, my lord, ever since your lordships came to the bar.
Nothing personal.
ಅದ್ರಲ್ಲಿ confusion
You
ಏನಿಲ್ಲ
are justified because sometimes ಹಂಗೆ ಆಗ್ತದೆ. ಎಷ್ಟೋ ರೂಲಿಂಗ್ಸು ಅದು ಇದು ಎಲ್ಲ ಕೊಟ್ಬಿಡ್ತೀರಿ ನೀವು. ನಾವನ್ನೆಲ್ಲ ಓದ್ಕೊಂಡು ಸಿಂಥಸೈಸ್ ಮಾಡಿ ನಂತರ ಫ್ಯಾಕ್ಟ್ಸ್ ಅನ್ನು ಇನ್ನೊಂದ್ಸರಿ ಓದ್ಕೊಂಡು ಅದನ್ನೆಲ್ಲ ಮಾಡೋ
ಅಲ್ಲ, ಅದು
ಎಕ್ಸರ್ಸೈಸ್
ಮಾತ್ರ ಅಲ್ಲ,
ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ದ ಲಿಟಿಗೆಂಟ್ ಕಣ್ಣು ಮುಂದೆ ಬರುವುದೇ ಇಲ್ಲ. ಒಂದು ಅಕಾಡೆಮಿಕ್ ಎಕ್ಸರ್ಸೈಸ್ ನಡೀತಿರ್ತದೆ.
ಅದು ಒಂದು. ಎರಡನೇದ್ದು, my lord, what happens is, ನಮಗೆ ಇಲ್ಲಿ ನೋಡಿ, ಇಲ್ಲಿ 3 ಜನ ಇಲ್ಲಿ ನಮಗೆ ಅಸಿಸ್ಟ್ ಮಾಡೋರು, ಅವರಿಗೆ 4 ಜನ ಅಲ್ಲಿ ಅಸಿಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಅಲ್ಲಿ ಅಫಿಷಿಯಲ್ಸ್
ನಿಮ್ಗೇನು ಅಸಿಸ್ಟೆನ್ಸ್ ಬೇಡ ಬಿಡಿ.
ಅದಲ್ಲ, ನಮಗೆ ಯಾರು ಇರೋದಿಲ್ಲ, ಫೈಲು ಇಷ್ಟಿಷ್ಟು ಇರುತ್ತೆ.
ರಿಯಲಿ
that, my lord, is my lord, is the greatest, my lord, hurdle for a judge. Because
ನೀವು ಹೇಳಿಲ್ಲ ಇವನ್ನೆಲ್ಲ ಎಲಿವೇಶನ್ ಆಗುವಾಗ ಸುಳ್ಳ ಏನೋ ಒಂದು ಬಣ್ಣ ಹಚ್ಚಿ ನಮ್ಗೆ ರಿಯಲಿ ನಮ್ಗೆಲ್ಲ ಗೊತ್ತೇ ಇರಲಿಲ್ಲ ಇಷ್ಟು ಟಫ್ ಜಾಬ್ ಇದು ಅಂತಾನೆ ಗೊತ್ತಿರಲಿಲ್ಲ.
Absolutely. It's a great sacrifice.
ಅವಾಗ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಇದು ಹೆಂಗೋ ಒಂದು ಎಂತದೋ ಒಂದು ಮದುವೆ ಮಾಡ್ಕೊತಾರೆ ಹಂಗ ಬುರ್ಕ ಓಪನ್ ಮಾಡಿದೀನಿ.
ಇಲ್ಲ, ಮನೆಗೆ ಹೆಂಡತಿ ಹತ್ರ ಹೇಳ್ಬೇಕು ನಾನು ಈಗ.
Really,
no.
Work
it is, my lord, that's why I always say, we put, my lord, the best of them on the top.
ಅದೇನೋ ಫುಲ್ ಕರೆ ಅನ್ಸಿಲ್ಲ. Anyway, whenever you want victims, you will say always that only. Never he told me. Only ಇದು ರೋಜಿ ಪಿಕ್ಚರ್ ಅಷ್ಟೇ ಹೇಳ್ಕೊತ ಹೋಗ್ಬಿಟ್ರು, ನಾವೇ ನಂಬಿರ್ಲಿಲ್ಲ ಪೂರಾ. ಆದ್ರೂ ಸಹಿತ ಏನಂತ ಈ ಸೀನಿಯರ್ ಸಿಸ್ಟರ್ ಹೇಳ್ತಾರೆ ಅನ್ಕೊಂಡ ರಾಘವನ್ ಅವರು, ಇವರು DLN ರಾವ್ ಅವರು, ಆಮೇಲೆ ಬಿವ್ಯಾಚಾರ್ಯ ಸರ್, ಇವರೆಲ್ಲ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, 2, 3, 4, 5 ಹಿಂಗ್ ಮಾಡ್ಬೇಕು ಇವ್ರು. ನಮ್ಗೇನ್ ರಾತ್ರಿ ನಿನ್ನ ಅಕ್ಯೂಸ್
I just recollect a small joke. There was a pool where all reptiles, crocodile, snakes was there. The person who swims across gets a $5 million. So all of them are wondering. Suddenly one man jumps across and in no time he's on the other side. Then they give him $5 million and they ask him to speak a few words. He says, "Who pushed me, man?"
Same thing has
So
happened.
now you know, my lord, who put it. Grateful, my lord.
ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಹೇಳಿ, ಒಂದು
ನಮಗೆ-
ನಿಮ್ಗೆ ಅನುಕೂಲ ಆಗುವಂತ ಒಂದು ಡೇಟ್ ಹೇಳಿ ಮಾಡಿ. ನೀವು ಸಹಿತ ಮತ್ತೆ ಬಹಳ ಲಾಂಗ್ ಮಾಡ್ಬೇಡಿ.
ಇಲ್ಲ, just-
ಏನು ವೆಕೇಶನ್ ನಲ್ಲಿ ನಂಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ಲಿಕ್ಕೆ ಬಿಡಬೇಕು.
Please, please.
ಐ ಹ್ಯಾವ್ ಡಿಸೈಡೆಡ್ ಟು ಪೆನ್ ದಿಸ್ ಜಡ್ಜ್ಮೆಂಟ್
Please.
ಡ್ಯೂರಿಂಗ್ ವೆಕೇಶನ್.
Please.
ಒಂದ್ 2-3 ಅಷ್ಟೇ ಇದೆ. ಒಂದು ಯಾವುದೋ ಒಂದು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟ್ರು, ಅದು ಡಬಲ್ ಟ್ಯಾಕ್ಸೇಷನ್, ಇಂಟರ್ನ್ಯಾಷನಲ್ ಟ್ಯಾಕ್ಸೇಷನ್ ಏನೋ ಮಾಡ್ಕೊಂಡು ನಮ್ಗೆ ಹಾಕ್ಯಾರ ಅದನ್ನ ಮಾಡಿ. ಆಗ್ಲಿ ಹೊಳ್ರಿ, ಯಾವ ಡೇಟ್ ಬೇಕು ಹೇಳಿ, ನಿಮ್ಗೆ ಬೇಕಾದ ಡೇಟ್ ಕೊಡ್ತೇವೆ ನಾವು. ಇಬ್ರು ಚೂಸ್ ಮಾಡಿ. ಅವತ್ತು ಮಧ್ಯಾಹ್ನ ಮಾತ್ರ ಯಾವ್ದನ್ನು ಇಡಬಾರ್ದು, ಪ್ರೆಷರ್ ಆಗ್ತದೆ ನನಗೆ, ಪ್ರೆಷರ್ ಆಗ್ತದೆ.
I know that.
29,
Yeah.
okay for us.
As it is, I know. Your lordship.
ಆಮೇಲೆ ಎಷ್ಟು ಕಮಿಟಿ ನಮ್ಗೆ
I know that. ಅಯ್ಯೋ, ಅದು ಸಾಯಂಕಾಲದ ಹೊತ್ತು.
ಆ ಕಮಿಟಿಗಳನ್ನೆಲ್ಲ ಮುಗಿಸಬೇಕು, ಆಮೇಲೆ ಇವನ್ ಮಾಡ್ಬೇಕು, ಬರೀ ಇದರಲ್ಲೇ ಹೋಗ್ಬಿಡುತ್ತೆ.
Most of the time in the evening is taken away by those, my lord. Administrative work plus that those committee
ಅದು.
decisions. You know
ಪ್ಲಸ್
that.
ಆ ಪಬ್ಲಿಕ್ ಫಂಕ್ಷನ್ ಒಂದು ಅವ್ರೊಂದು
ತಾವು ಅಲ್ಲ,
ಹಾ.
ನಾವಿಲ್ಲ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ, ಅವರು ನೀವು ಬಲ್ಲೇಬೇಕು
ಏನೋ
ಅಂತ.
ಒಂದು
ಹೌದು. And plus some, my lord, obligations so that you can educate the society.
ಅವ್ರಿಗೆ ಅದು ಬೇಕಾಗಿತ್ತು ಸ್ವಲ್ಪ.
ಯಾವತ್ತು
ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು?
29ನೇ ತಾರೀಕು ಆಗ್ಬೋದಾ?
29
ಫ್ರೈಡೆ ಬರುತ್ತಲ್ಲ, ಏನಾದ್ರು ತೊಂದರೆ ಇದೆಯಾ ಬೇಡವಾ?
ಮಧ್ಯಾಹ್ನ ಇಟ್ಕೋಬೋದಾ? 29 ಮಧ್ಯಾಹ್ನ ಇಟ್ಕೊಂಡ್ಬಿಡ್ತೇನೆ.
ಆಗ್ಬೋದು, ಆಗ್ಬೋದು.
My lord, after,
ಅಕಸ್ಮಾತ್ ಏನಾರ ನಮ್ಗೆ ತೊಂದರೆ ಇದ್ರೆ,
Yes.
ನಿಮ್ಗೆ ತೊಂದರೆ ಇದ್ರೆ ಹೇಳಿ,
ಇಲ್ಲ.
ಮತ್ತೊಂದು ಡೇಟ್
my
ಮಾಡ್ತೀವಿ.
lord's one humble submission. After learned senior finishes,
Ah.
Mr. Raghavan is not available on that day. The next day he will finish.
ಇದ್ರಾಗ ಹೊಂಟ್ಬಿಡು.
ಹಾಗಾದ್ರೆ ಇನ್ನೊಂದು ಯಾವತ್ತವ್ರು ಯಾವತ್ತಿದ್ದಾರೆ ಹೇಳಿ?
ಇಬ್ರು ಯಾವತ್ತಿರ್ತೀವಿ ಅವರು, ಆಮೇಲೆ ಏನಾಗ್ತದೆ,
ಮರ್ತೋಗ್ಬಿಡುತ್ತೆ ಇವರಿಗೆ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಾರ್ದು.
20
ಹಿಯರಿಂಗ್ ಅಂದ್ರೆ ಬರೇ ನಾವು ಮತ್ತು ನೀವಲ್ಲ, ನಿಮ್ಮೊಳಗೂ ಏನ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಿ ಅಂತ ಗೊತ್ತಿರಬೇಕು. ಯಾಕಂದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಮೀಟ್ ದ ಪಾಯಿಂಟ್ಸ್ ರೇಸ್ಡ್
Yes,
ಬೈ
please.
ಈಚ್ ಅದರ್.
Could it be on 26th,
26th ನಮ್ಗೆ ಡಿವಿಷನ್ ಬೆಂಚ್,
26, 27, 28?
ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲ,
First week of,
ಡಿವಿಷನ್ ಬೆಂಚ್ ಇರುತ್ತೆ.
second or third? Yes,
ಏನ್ ಬೇಡ.
third.
ರಾಘವನ್ ಔಟ್ ಆಫ್
5th or
ಕಂಟ್ರಿ
6th?
ಇದಾರನು.
He is out of station. He is going to be back on 26th.
5th or 6th ತಮಗೆ ಯಾವತ್ತು ಆಗ್ಬೋದು ಹೇಳಿ? 5th ಆದ್ರೂ ಆಗ್ಬೋದು.
Fifth is slightly,
Friday.
but fifth is slightly inconvenient to me, my lord, but I may not take more than 26th.
ಆಗ್ಬೋದಾ?
6ನೇ ತಾರೀಕು.
Yes, ma'am.
Please.
6ನೇ ತಾರೀಕು.
6th ಹಾಕೊಂಡೆ. ಪ್ಲೀಸ್ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ನಾವು ಮುಗಿಸ್ಬಿಟ್ಟು.
2:30.
2:30.
ಅವತ್ತು ಯಾವ ಬೇರೆ ಮ್ಯಾಟ್ ಹಾಕ್ಬಾರ್ದು. ಬೆಳಗ್ಗೆ ಅದು ಮುಗಿಸಿ ಮಧ್ಯಾಹ್ನ ಇಟ್ಕೊಂಡು
Please.
ಥ್ಯಾಂಕ್ ಯು.
Grateful.
ಹೊರಡ್ರು ಕೊಟ್ಟಿದ್ದು. ಸರ್, ನಿಮ್ದೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ
ಇಲ್ಲ ಮಾಡಿ.
ನಿಮ್ಮ
ಇಲ್ಲ, ಒಂದು ಮಾಡಿದ್ದೀನಿ ನಾನು, ಅದನ್ನ ಸ್ವಲ್ಪ ಇನ್ನು ಫೈನಲೈಸ್.
ಅಲ್ಲ, ಅದು ಅವ್ರು ನೋಡ್ಕೊಂಡು
ಅವ್ರದ್ದು ನೋಡ್ಕೊಂಡು ಮಾಡಿ,
ಅದಕ್ಕೆ
ಅದಕ್ಕೆ ಕೊಡ್ಲಿಲ್ಲ.
ನೀವು ಸಹಿತ ನೋಡ್ಕೊಂಡು ಮಾಡಿ. In days are not far away when judges, at least a section of judges would ask for draft judgments also, not only draft issues.
Yes, ma'am.